Welcome to Medmarc's webinar series. Today's presentation is titled Overcoming Unique Issues Regarding Trademark Searching and Filing for the Pharmaceutical Industry. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Leo Loughlin and David Schiavetti, thank you for joining us. Leo Loughlin is a partner in Rothwell Figg's Washington, D.C. office. He has over 20 years of experience assisting clients with registering and protecting trademarks through counseling, prosecution, and litigation. At the most fundamental level, Leo assists clients in developing and protecting their brands. On the development side, he assists in searching when a new brand is needed and filing for protection of that name. Once protection is obtained, he further assists the client in maintaining that protection, often through enforcement. Leo has filed well over 1,000 trademark applications, both with the U.S. Patent and Trademark Office and abroad. He counsels both large multinational corporations and startups in a wide range of industries, including pharmaceuticals, fashion, automotive, food and beverage, software, financial services, agricultural equipment, and consumer products. David Schiavetti is an associate in Rothwell Figg's Washington, D.C. office. Originally from Milan, Italy, and fluent in French, Italian, and Spanish, David specializes in counseling clients from European countries on navigating the legal, trademark, and copyright aspects of their entry into the North American market. Although his clientele spans the European continent, he is particularly active in representing companies from Italy. Brands he counsels in trademark law include some of Italy's most well-known global names, such as Valentino, Ferrero, Lavazza, Barilla, and Fiat, among others. David counsels clients in trademark prosecution in the U.S. Patent and Trademark Office, as well as litigation in both federal district courts and the Trademark Trial and Appeal Board. And with that, I am pleased to turn things over to Leo.
Thank you, Kate. Thank you for the nice introduction. Good afternoon, or hello, everybody, or wherever you are. It might not be afternoon, but it's afternoon where I am. So, welcome. As Kate mentioned, my name's Leo Loughlin. I'm a partner at Rothwell Figg's DC office. I've been practicing trademark law now for about 26 years, and as mentioned, I counsel clients in a wide variety of industries, including pharmaceutical, automotive, agricultural, fashion, food and beverage, software, AI, and numerous other industries. In all those years I've been doing this, there is some unique issues that come up when you're assisting clients in the pharmaceutical industry secure trademark rights for their products that they're trying to launch into the market. And we thought it was a good idea to try to go over this today because we think it'll be very helpful because there's a lot of tools you can utilize to help you more easily secure rights and hopefully make the process a little easier. Trademarks in the pharmaceutical industry are important, not only a part of a company's intellectual property portfolio, but as a matter of public health. And obtaining a trademark registration, raises these unique issues and considerations that need to be carefully navigated. Whether it's selecting a new product name, formulating a clearance strategy, filing and prosecution applications for marks, there are processes and techniques that help avoid, if necessary, overcome roadblocks from various possible challenges, whether it be from the Food and Drug Administration, the FDA, the U.S. Patent and Trademark Office, or sometimes from third parties who may object to your proposed trademark use. So we're going to try to talk about that today and see if we can help give you some useful tools to help overcome some of these issues. Next slide, please. So rather than just put up on a screen the technical definition of a trademark, I thought this quote from Saul Bass would be useful. For those of you that don't know, Saul Bass was a real innovator in Hollywood in the 20th century. He worked on filmmaking with Martin Scorsese and Alfred Hitchcock. He was also a very influential designer. Just not to spend too much time, but Mr. Saul Bass, he designed the United Tulip logo that you see on planes. He designed the Warner Brothers logo. He designed the Hanna-Barbera logo. He designed the AT&T Globe logo. So this is someone that really knew trademarks. And his quote here, I think, speaks to the heart of what a trademark is. The ideal trademark is one that is pushed to its utmost limits in terms of abstraction and ambiguity, yet it is still readable. Trademarks are, in a certain sense, thinking made visible. That I think that really captures it. Just to get the technical definition, when we say people say, well, what is a trademark? As I heard I took a class in law school in the mid 1990s on trademarks, and the professor the first thing he said in the first day in class was something I've never forgotten. He said, "What is a trademark?" He said, "A trademark is any symbol, be it words together, design, logo, anything that has what we call in the law source identifying function." A source identifying function. It means it identifies the source, the the entity that's supplying the goods or services. When you're on the road and you're traveling your car, you see two large golden arches. Oh, here's a place we can go get a burger and fries and a shake, and sometimes some soft serve ice cream, but usually that's not available. When you're in a store and you see a sign with a swoosh, okay, these are Nike products. We can get athletic shoes here. For things like, I look at my, when I put my TV on at night, and now that we have all the apps on our team, I can see the stylized N. I say, oh, well, here's a show. Here's where I go to get Netflix programs. So these are all what we call trademarks, are what we call source identifying function, that identifies the manner, the source of the product that you want to get. And it's the source, it's going to be the nature and the quality, the entity providing this product stands behind it. Next slide, please. And as I mentioned earlier, trademarks in the pharma industry are important, not only as part of a company's intellectual property portfolio, as a matter of public health. It's important, especially important. It's always important that purchasers are getting the right products that they're looking for, and trademarks serve in that. But it's an added protection in the pharmaceutical industry, because you have pharmacists, healthcare providers, patients, providers, patients, family, and it's important that trademarks operate their unique function to identify source. And there's many considerations when selecting a new product name. There's the FDA, and that is the FDA going to approve the name. That's a process that David will help touch on later. Competitors. If you go out there and you say, if you want to launch a new drug, you want to call it Ozempic with an X, Novo Nordisk may want to have a talk with you. Not going to like that very much. So it's important to steer clear where, again, the source identifying function, meaning which the public sees, and they know where the source is. And if things are too close, if names are too close where it gets confusion, then that's not good. And that's when sometimes the courts have to step in if the parties can't resolve it. Attractiveness of name. It's important. You want people to buy, companies want the public to buy their products. They want something that sounds good and sounds nice. I was looking at some famous brands coming in. AbbVie makes Humira. It's a great name, Humira. It sounds awesome. So these are things, attractiveness of the name. But not. Last consideration is not too descriptive. That's another. It's a fine line. That David and I we navigate every day in our practice. Is it's good to tell a little bit about your product if possible, but not too descriptive, because first of all, you're not going to get a trademark on it most likely. So you don't want to launch a new product and call it blood pressure reducer. That's not going to. First of all, it's not going to be a very successful name for your product, and you're not going to get a registration for it from the USPTO. Next slide, please. That comes a question. and just to touch on things a little bit, there where the U.S. is a bit unique from the rest of the world, which is probably not a shock to many of us on this webinar. The U.S. kind of does things their own way, which gets to the point of this slide about registering a trademark. In the U.S., unlike a patent, you don't need to register you don't need the USPTO's permission to have a trademark. Trademark exists upon what they call use in commerce. The U.S. is rather unique in that the U.S. recognizes common law trademark rights. What does that mean? It means if I go out there and I sell I make iced tea in my house and I go out and sell it and put my brand Leo's iced tea on it and sell it, I've got trademark rights. Whether I've registered or if I applied for a trademark or not with the USPTO, we have common law trademark rights which exist upon use in commerce. Which means use, sale, or transport with the public. So common law trademark rights exist in the U.S., not in a lot of other countries, but they do exist in the U.S. And common law trademark rights in the U.S. are enforceable. They're very enforceable. The federal laws protect common law trademark rights. The federal trademark laws, what we call the Lanham Act, the technical term is 15 USC 1125A, talks very clearly about common law trademark rights may be enforced in court, and you may obtain all the regular remedies that you can get if you're trying to enforce a registered trademark. Of course, there's not to get too into the weeds on that, but there's evidentiary issues that there's hurdles you have to climb to establish things. If you have a registered mark, to use a baseball terminology, you start the litigation on second base, and you only have to get two bases to get home. Whereas if you have a common law trademark, you have to go to all four. So there's evidentiary advantages to a registration. But aside from that, why register a trademark? First of all, we think we always counsel clients that in most circumstances, it's almost always advisable to register, to file a trademark application with the U.S. Patent and Trademark Office. And what are some of those reasons? It protects your reputation and consumer loyalty, having a registration, because it serves as notice. It gives you stronger enforcement rights. It also gives constructive notice. What does that mean? Because trademark rights exist, because the registered trademarks are on a publicly available database at the U.S. Patent and Trademark Office. That gives what the law calls constructive notice. And if someone comes along and copies your trademark and they say, "Well, I didn't know about it. I didn't know about you had a trademark for this." As well, technically, you had constructive notice because you could have taken 30 seconds and searched the USPTO's database of registered trademarks, which is very user friendly, very easily searchable, and come up with that. The last point. And just get back to enforcement, you can bar. It helps to bar infringing imports. If you have a registration, it's much easier to do that, and it's much easier for cease and desist if you need to contact a third party. Having done a lot of these types of letters to third parties, what we call nasty little letters. Sometimes we try not to be too nasty, only sometimes. But it's much easier if you have a registration that you can cite to say, "Hey, my client has this registration. Here's what's attached to the letter." It just makes things very easy. The last one is, nationwide rights it's not as big of an issue in 2024 as it was in 1954, where, given the advent of the internet, but technically it does give you nationwide rights. When we were in law school, we used to study these cases about, the Burger King in Maine versus the Burger King in Arizona, and who has rights. And, the one at the registration has presumptive nationwide rights. Not so much of an issue as today, but it still does play a part. And one point that's not on here, another consideration why we recommend filing a trademark application rather just relying on going the common law route, is trademark applications are fairly inexpensive. The U.S. government charges $350 per class. There's not a ton of attorney work involved, so there's not, it's not like a patent application where you're getting into $15,000-$20,000 just to get it on file. Trademarks applications can be done for a few $100s. So So the financial consideration is not. Given the added benefits you get from a trademark registration, we strongly caution in most cases our clients to pursue a trademark application. And one other consideration, like Columbo here, is it overseas. If you want to take it, this is especially important in the pharmaceutical industry. If you want to, if you want to file your trademark, get protection in other countries outside the U.S., it's much easier if you have a U.S. trademark registration, because the U.S. is part of the Paris Convention, and which means if you have a registration or application in the U.S., you can file it in nearly every other country in the world and claim priority back to your U.S. filing date. So you file it once, and as long as you file within the first 6 months of after filing in the U.S., you can claim priority in almost every country in the world back to your U.S. filing date. So that's a tremendous consideration. There's also you can also go use your U.S. application to go through the Madrid International Filing System as well. Which so if you want to file outside the U.S., it's very important to get an application out filed in the U.S. Next slide, please. So what are some initial considerations that we want to look at when we're counseling clients on trademarks? First of all, the one is we'll get to this slide in a minute, but for now, I just want to say you want to understand what they call the spectrum of trademark strength, which as with anything, some brands are stronger than others, whether it's strength in the it's renowned to the public, or it's whether it's the spectrum of trademark strength, whether it's something that's really weak, descriptive, or whether it's very strong. Also, you want to avoid including literal elements and words in connection with ingredients. This is considered descriptive. So you want to, if possible, keep descriptive words, keep ingredients out, keeping out of the name of your brand, because that can lead to issues with with the USPTO, and also it makes your mark harder to enforce if you're because you can't claim a monopoly on an ingredient, the name of an ingredient, which people may try. So that's something you want to. And the last one, you want to avoid similarity with existing trademarks brands, because first of all, it's USPTO does do a search when you file a trademark application. They do a search of everything else that's been registered with them, and if it's too similar to another mark that's already registered or prior pending, they will reject it. And sometimes they can be difficult to overcome. Not always. We'll talk later about some tips to overcome it, but it's best if you don't have to try to overcome it and try to pick something that's not too similar to existing brands. Next slide, please. So we talked about the spectrum of distinctiveness, and here it is in graphic format. And it's probably how you pick the strongest trademark. And this goes back to this isn't a law school class, so I'll get too much into the case, but you see these terms towards the bottom: generic, descriptive, suggestive, arbitrary, and fanciful. They're what's known in the law we call the Abercrombie and Fitch, spectrum of distinctiveness. There was a case about, I believe it was the Second Circuit, about almost 50 years ago, that talked about this distinction between different types of marks. This we call the spectrum of distinctives, where the weakest on the left and the strongest on the right. So the weakest being generic, strongest being fanciful. So just go through this for a minute. What's a generic mark? A generic mark is, the example we have there is smartphone. A generic mark is just the name of the mark. Excuse me, the name of the product. Smartphones is an example there. Pizza for a pizzeria. Iced tea for a bottle of iced tea. A generic name can never ever have trademark significance. It's because it's the name of the product, so it can't never have trademark significance. No matter what evidence you put on of the public associated with it, can never have it. So there's the reason why is very common sense. Generic, if you want to, smartphone, Apple can't claim that somebody else can call it a smartphone. Samsung say, what's your product? It's a smartphone. Back in the late 90s, there was a company that obtained a trademark registration in the early 1990s for the term internet. So if you go back, so there was a period of years when you filed trademark applications in the 90s, you couldn't use internet when you were describing your goods. That's why if you look at trademark registrations from the 90s, they had very obscure descriptions of goods like information via a global telecommunications network, inputting images and things like that. Eventually, it was decided that internet's generic. You can't. Everybody should be free to use it. So generic terms can never be protected. Descriptive terms is the next one up. Normally not protected. Descriptive means it's not generic. It's not the name of a product, but it describes an ingredient, a characteristic. Here we use Windows. It describes an aspect of the product that doesn't identify the source, but describes the product. Now, descriptive marks by themselves are not protectable as a trademark. However, descriptive marks can be protected upon a showing of we call secondary meaning, meaning that the proof that the public associates that mark with a particular source. Obviously, when you see Windows in that format, the public associates that with Microsoft. So obviously, that secondary meaning. The next term is suggestive. It means a suggestive term and means it gives some indication of the product. When you see Microsoft, it's like, well, it's probably got something to do with computers or software, but I don't know exactly what it is. That means the mark's suggestive. And suggestive marks are what we call inherently distinctive and may be protected upon use. You don't need to add any evidence. In our line of work, the line between descriptive and suggestive it's a very gray line, and we find ourselves on either side of this kind of fighting with the USPTO. The next term is arbitrary. That means it's a word that's known to the public, but it's being used in a word not connected with that. Probably the best example of this we have here is apple. Apple is a word, it's a fruit, but it's in the world of computers, it has nothing to do with that. So, Steve Jobs chose a term that was a common English word that was arbitrary, and that's Apple. So that's why arbitrary marks can be protected. And fanciful is the strongest type mark that means it's a totally made up word. Exxon. Exxon is just a made up word, and it's a fanciful mark and it gets protected. Next slide, please. And again, as I mentioned, you want to avoid including literal elements, the name of ingredients, you want the name of the indication, the name of purpose. These are all things that you want to avoid in choosing your name. Next slide, please. Now we get to one of the most important aspects of selecting a mark in the pharmaceutical industry is existing brands. And first thing you do is you want to do a search. And David's going to get into that, the details about searching in a couple minutes. And the way you avoid similarity to existing brands is to do the search. You can do them yourself, we typically use a vendor. That helps eliminate issues with the USPTO and third parties, because if something search list comes back and there's something there, you can talk about, well, there's no sense in going farther with that. And oftentimes with pharmaceutical clients, we get like 10 different marks, and they'll say, these are the 10 we came up with, what do you think? And 8 of them look fine and 2 of them no. So but that's how we help avoid that. Next slide, please. And at that point, lucky everybody on this call, you can now hear from David, and I'll be quiet.
Thank you, Leo, and good afternoon, everyone, for joining us on this for this webinar. So I will discuss a little bit more in detail the options brand owners have to search for the availability of a particular trademark. The availability search is a critical phase in the clearance process of a trademark because it searches for potentially similar trademarks that have seniority of use in the market. I'm tying this into what Leo discussed a little bit earlier, which is the US is kind of different jurisdiction compared to many other ones around the world where brand owners accrue trademark rights based simply on using the trademark in commerce and not necessarily by filing a trademark registration. Other countries are so-called first to file, meaning whoever first files a trademark application for that particular term will be considered the senior user or the user with the most rights. That's not the case in the United States, and that is why there are various types of searches that have to really kind of give the brand owner a more comprehensive idea of the use of a certain term in the market. So of course, a brand owner will conduct an availability search and have to try and determine the scope of protection because since there are different types of searches that search different databases, that is a critical element in the decision. And then these searches essentially tackle one of the elements that Leo mentioned earlier, which is similarity of existing marks. They don't necessarily look at the descriptiveness of the mark, but really just what is in the market at the time of the search and what could be the potential repercussions of releasing a product that carries a name that is similar to an existing product. And that is the assessment of risk of conflicting marks. The types of searches are, there's various ones, but two of the main ones that we typically recommend for brand owners are a so-called federal search. The federal search will essentially give the brand owner a snapshot of every existing live or abandoned also registration on the principal register. The Trademark Office has essentially two registers. One is the principal register, which is obviously the main register, and then there's a supplemental register, which is used for descriptive marks. Sometimes it is possible, for example, to obtain registration on the supplemental register, and based on continuous use in commerce for a certain number of years, then it is possible to rely on that use and the fact that consumers in the market are familiar with the mark to then refile for the principal register. That is just to kind of differentiate the two. But the federal search would also look at WIPO extension of protection, and that, as Leo mentioned before, it is possible to file through WIPO, which is the World Intellectual Property Organization, and through WIPO, it is possible to file in several different countries from one central application that then gets extended to the various national trademark offices. So a foreign or US entity can file through WIPO and then designate all countries that are essentially members of WIPO. So that's what we typically mean by extension of protection. It means that that particular registration or application has been designated to be extended to the United States as well. And the Trademark Office will process that somewhat similarly to a national application, but of course they will still have the same rights as long as they are registered on the principal register. So it's something that it's still very useful to kind of assess in terms of similarity of existing marks. And then we have a much more comprehensive search, which includes essentially all the elements that will allow brand owners or users of a particular mark to understand what is the use of that term commercially. Because it is not necessary to file a trademark registration to be the owner of trademark rights, of course, a thorough search would require, for example, looking at the common law, domain names, business names, web pages, and again, the WIPO extension of protection. So just a couple of examples. For example, someone incorporates a business with a certain term, and you would find out exactly how many businesses use that term as their own business name, what is the industry of operation, and so forth. Same thing with domain names and web pages. Of course, if someone simply sells their products, for example, on some of the social media platforms, think of Facebook, Instagram, and so forth, they may not have a trademark registration, and it may not be picked up on the federal search because it's not on the principal register. But it would be picked up by a comprehensive search where, the hit obviously would show that there's a product named Apple, for example, that has been sold on Facebook or Instagram for that particular type of good that we're searching. Next slide, please. Yes, so essentially the federal and comprehensive searches are searches that we recommend for any type of brand owner, irrespective of the industry. Now, obviously the pharmaceutical industry has some specificity to it. And so there are also specialty searches available for pharmaceutical brand owners. One is the US Pharmaceutical Search that includes essentially the Orange Book, POCA rankings, and then fairs and usernames. Essentially, the most important element to really think about here is that there are obviously some regulatory elements that are very important in terms of considerations to make for selecting a brand for a pharmaceutical. The phonetic and orthographic computer analysis, the POCA rankings that essentially divide the availability of a term into 3 categories: under 50%, between 50 and 69, and over 70. And then the adverse event reporting system and the vaccine adverse event reporting system. Then there's also industry databases that are really important to search, the World Health Organizations, for example. And then there's a more specific US FDA POCA search that searches the FDA Orange Book, and then drugs at FDA and RX1. So of course, these are add-ons that are specific to the pharmaceutical industry that can be added to a federal or comprehensive search because there are these regulatory elements that are specific to these type of products. Next slide, please. Right, so we received the report. So how do we really interpret these results and how do we assess the risk? So the main issue, the main element that we're really assessing here is the likelihood of confusion element. So it is trying to assess whether there are any senior users that are using trademarks that could be potentially similar to the one that we're trying to release in the market. And how do we really do that? Well, the assessment is based on the so-called Loughlin factors, and we'll look at them more in detail in a few minutes. But essentially, it's a balance of all these factors. No single factor is determinative, but it's really, courts typically really have to undertake a deep analysis of all the factors and balance all of them together. Then the other element that is really important, and that is an element that I think is really worth considering, is an entity assessment. What we mean by that is we really look at the owner of that potentially similar mark that has been identified in the search report and do an analysis on their behavior. For example, how often do they actually oppose third-party marks that could be similar? So how aggressive are they in enforcing their mark? Are they a US entity or a foreign entity? A US entity may be more willing to enforce their rights in their home jurisdiction as opposed to a foreign entity that may consider the US as just a second jurisdiction or simply an initial expansion of their business and market, and may not be willing to necessarily enforce their rights as aggressively as someone's home jurisdiction. Then, of course, we look at the registered marks. What this means is, for example, in comprehensive searches, we have both the principal register and the state registers. Now, as Leo mentioned before, in 2024, the state registers are not as, I guess, key as they may have been in the past. Of course, the country is well united in a federal system, so registration on the principal register is really what we're looking for, but the state registers may give an idea of more of use that is more geographically limited to certain areas. And that could be an interesting assessment in terms of the willingness of the brand owner to actually enforce their rights in other areas. And then the common law, because as I mentioned earlier, really looks at an array of different things. For example, web pages, social media, domain names. It really gives a snapshot of what the use is in commerce. And that is one of the main differentiating factors between the system in the United States and many other jurisdictions. The register really is considered to be a snapshot of what is really going on in the market. And that is why there are very stringent use requirements that we'll briefly touch on later. But as opposed to other countries where simply it is possible to file a trademark registration and use will not really jeopardize the registration. In the United States, maintaining that use in commerce is key to being able to continue having that registration and enforcing those rights. And so these common law searches really give that view, that holistic view of the use in commerce of a particular. And this, going to the marketing and advertisement, is really important because it doesn't really, having these common law rights or this use in social media, web pages, and so forth, domain names, it's really to understand from a marketing and advertisement perspective, whether a mark could be a good investment or not, as opposed to simply from a legal perspective, whether we would be susceptible, for example, to a lawsuit, or infringement lawsuit, or other type of enforcement. Next slide, please. So how to minimize formality refusal. So this is kind of it's a very tricky question. What that means is essentially when brand owners file a new trademark application, the examination of the Trademark Office can result in what's normally called an office action, which is a result of the examination, and can, in most cases, probably 95% of cases, there will be an office action, but there can be different types of refusals in it. So the main differentiation is between formality refusals and substantive refusals. We'll look at the substantive in a minute, but formality refusals really address some basic elements of the application, meaning, for example, the description of goods and services, the entity status, the address, sometimes color claims. If the mark obviously has, there has to be a color description in the application if the mark has a particular color in it. So these are all considered formality refusal because they can be addressed somewhat easily just by making slight modifications to the application. So one of the main ones that it is very important to kind of try and address at the very outset to minimize the chances or the extent of the refusal is tailoring the description of goods and services as much as possible. What that means is, of course, use a trademark manual of ID. That is a PTO resource that lists essentially all approved language for a particular good or service that will not be refused based on being too vague or ambiguous by the Trademark Office. Now, unfortunately, it's not as simple as it may sound, because even though there is a trademark manual of ID, it is very common to receive refusals based on formality, because every single element in the application, so every single product, every single service has to be qualified. What does that mean exactly? It means, for example, as I included in the slides, for a skin condition, it is not sufficient to simply mention that that particular drug addresses skin conditions, but it's really important to specify which ones. And the more specific the qualification is, the more likely it is that the examination will sail through without issues in terms of being too vague or ambiguous and receiving that formality refusal. Now, there's a balance to be considered though, because it is not possible to add classes after filing. And by classes, for those who may not be familiar with the system, every application has to include classes. So products fall under certain classes. They're called the NIS classification system. And it's an international classification system. So every product falls under a particular class. What is possible to do is to modify the description of goods and services within one class, but it is not possible after filing to add classes unless the Trademark Office suggests to do so. But especially it is not possible to do after registration. So on one hand, we have the necessity of trying to be as broad as possible because you may expand the scope of the products, the goods and services that you will be marketing under the mark. But on the other hand, we have two limiting factors. The first one is we have to be as specific as possible to try and avoid formality refusals and use requirements. What I mean by use requirements is every application filed with the Trademark Office has to either be based, generally there's other filing bases, but the two main ones are use in commerce and then intent to use in commerce. The main difference there is that for the use in commerce, essentially we're declaring that that particular mark is already in use in the United States in commerce in relation to those goods that are included in the description of goods and services, and all of them, not just some of them. And then intent to use essentially allows the applicant more time to try and finalize the description of goods and services, or to finalize obtaining specimens, so proof that there's actual use in commerce in relation to certain goods and services in a span of time that can go up to 2.5 years, really, by paying extensions. And that really allows brand owners to kind of reserve the mark in a way, even though it's not technically allowed, but to reserve their priority over a certain mark while they're still finalizing the last elements of their product and their release to market. So there are these two elements: one, having to trying to be as broad as possible so that it's not needed to necessarily file a new application for new goods and services and new classes, but also mindful of these limitations. The next slide, please. Right, so second type of refusal is what we call substantive refusal. Some of the main ones that I think are more relevant to the pharmaceutical industry are likelihood of confusion and descriptiveness. Leo has touched on these a little bit earlier in his presentation, but essentially for likelihood of confusion, we're really addressing situations where the Trademark Office issues a refusal and says, well, actually, there are already these marks registered on the principal register that we believe are too similar to the one that you're trying to obtain a registration for, and that would cause confusion in the market. And because the ultimate goal is to avoid consumer confusion, especially in a situation where the product is a pharmaceutical, we're refusing registration of this mark. What are some of the key elements to kind of look for? What are some of the arguments that can be made? How do people overcome these kind of refusals? Well, there's a lot of considerations, but to try and make it as simple as possible is, first of all, try to see how many marks exist currently on the register that encompass similar wording, similar syllables, similar number of letters. This allows for an argument that the term is not particularly strong because already in the market, there are a lot of different companies, entities different sources, going back to the source identifying language that Leo used earlier, that use that particular term to identify their product. Now, if there's several of them in the market, then consumers are not necessarily going to be confused if one extra entity enters the market with a mark that is similar. Now, if there's only one, then that is problematic because then consumers are more likely to identify that particular term or any similar term to that with that particular source, and that is the cause for confusion. This is what we also refer to as term weakness. And it's one of the important elements to consider for trying to overcome a substantive refusal. Then the second element that is very relevant for the pharmaceutical industry is consumer sophistication. Consumer sophistication is certainly a consideration when it comes to addressing whether confusion is or is not likely. And that is because a sophisticated consumer may be more versed in the technical aspects or elements of a particular product, and will of course use that knowledge to make their decision as to whether they're going to purchase or not that product, and as to whether that product actually is identifies that particular source or not. Into consumer sophistication, there's also another element, which is the idea of an impulse purchase. That means that, of course, goods that are very inexpensive or goods that are purchased based on an impulse are more prone to cause confusion in the market because consumers don't really stop and reflect as to whether that product actually comes from that particular source or not. They're simply trying to buy that product quickly, and they're not really deliberating the source. Now, for example, if someone buys a car or an expensive product or a pharmaceutical, where of course there's elements of not just price, but also health consequences. Now, those are typically not considered impulse purchases. And so this is an element that definitely helps in arguing that even marks that may be similar on their face, they may not cause confusion in the market. And then this obviously ties into the fact that it's a regulated industry. For descriptiveness, as Leo mentioned earlier, for the pharmaceutical industry, it's really important to remember that any word or part of a word that refers to a feature, function, or ingredient especially is considered an element of descriptiveness and may cause a substantive refusal. The way to kind of argue that fine line that Leo mentioned earlier between suggestiveness and descriptiveness is whether a consumer would the term would directly convey that idea of product. So meaning if a consumer encounters this product in the market, would they immediately understand what that product is? If the user has to engage in what courts have called mental gymnastics, I've always loved this term, is essentially sufficient to try and argue that it's not really descriptive, but rather suggestive. Next slide, please. And here we have some of the main factors in the DuPont analysis. There are a total of 13. I included some of the most relevant for the pharmaceutical industry. So of course, similarity of the marks, it's the main premise of the presentation, but also the main premise of trademark law, trying to avoid confusion in the market with similarity of the goods. Then we have trade channels. This is another important element, whether a good is, for example, available just in physical locations, so physical stores on the street, or only online, plays a part in determining whether consumers would be confused because they would essentially encounter the two products that we're evaluating through the same trade channels. So for example, just a good example would be thinking of a supermarket, and you have a shelf and you have two products, one next to each other, that have similar names. Well, that obviously is an enhanced likelihood of confusion, as opposed to, for example, one of the two only selling online and not in physical stores, and so not really ending up next to a mark that may be similar. Sophistication of consumer, as I mentioned earlier, and then number of similar marks for term of weakness, and then fame. Fame is an element that kind of is complementary to the discussion about descriptiveness, suggestiveness, and so forth. In our slide earlier, there was windows as a descriptive mark. Now, of course, they're a very famous mark now. So the fame essentially helps the brand owner to enforce the rights, even in a mark that is technically descriptive. But that is something that is accrued over time and has to be proven by surveys or other elements that will show that consumers associate that descriptive word with that particular source. Next slide. And here I pass the mic back to Leo for the last part of the presentation. Thank you.
Thanks, David. So you've done the search as David helpfully explained. You've got it. You filed the application. You got it through. You overcame all the issues with the USPTO rejections and got it through. Got approved for publication by the USPTO, and then you get a third-party challenge. Another party entity files an opposition or sends you a cease and desist letter saying, we are filing opposition. You want you to stop. Well, what are your options there? Are the options just, well, either abandon that mark or option two, get into a extremely expensive litigation with this other party. Those are two options, but they're usually not the most common options. And there's better options out there. We often see this, especially in the pharmaceutical industry, where there's so much out there. There's so many products out there in the field. There's so many different uses of pharmaceuticals that there really are ways to resolve these types of challenges. One of the ones you see here, I says, what we found has been useful in resolving challenges from third parties is to narrow goods. I have a note here. We did this last year where the client was convinced we were going to have this long, expensive litigation. And I talked to opposing counsel, and he says, "Well, look, what my client really does is just their products are related to treatment of blood disorders." And I was like, "Well, how about we just amend our application and say excluding treatment for blood disorders?" And he says, "Let me check." Comes back a day later, says, "Done." They're fine with that. Easy, got an easy amendment, got around it, got the registration through. So I just wanted to point out that if you get a challenge, you get a challenge from a third party, it's not give up or dig in for World War III. There's ways we can do this, and coexistence agreements, exclusion for treatments or indications. Those are ways these can be, oftentimes, not always, you never know, but oftentimes these can be resolved on a fairly, quick and easy basis. Next slide, please. And I want to touch on real quick the filing of proof of use at the USPTO, because that's the last step before you get the registration. As David mentioned, most pharma applications are based on intent to use for common sense reasons. It's a long process either to get the patent application through and to get approval from the FDA is a several-year process. So a lot of our clients start this early, right at the initial, so they can lock their trademark rights for the brand they eventually want to use. They want to lock that in early on. But you get it approved, you get through publication, no third-party challenges, and then the PTO will issue what's known as a notice of allowance, and you get an initial 6-month period to prove use. And then you can extend that for up to 3 years from the initial notice of allowance that you have time to prove use in commerce. You have to file proof, which is what we call a specimen, showing proof of use of the mark in connection with the product on at least one of the products that you've applied for per class. What is use? The Trademark Act defines use in commerce is sale or transport. Sale or transport. So if you're selling product, oftentimes that's not happening at the early stage. So maybe an experimental use, maybe just be testing. But transport is something to keep in mind. It's important, and it's legally use in commerce. It legally qualifies as use that the USPTO will accept. So if you're shipping from your if you're shipping from your manufacturing plant to a hospital for testing in a 5 states away or the next state over, or from Maryland to Washington, D.C., where I'm from, that qualifies as transport and commerce. So that's acceptable use. The kind of use, it has to be in connection with the product. So we're talking packaging. On the box is fine, on the bottle is fine, on the cap, it could be on the product itself. Sometimes you have a lot of pharma products, it's in the little capsule or pill. You see the brand, the trademark in there. So it can be that type of use. For pharma products or the actual products, advertisements are not generally accepted. And that's something we get all the time. So we'll get like a brochure for a new product. So, well, that's not really accepted. We need something more than that. There's like a lot of things, there's exceptions, but for the most part, no, advertising is not generally accepted for a pharma product. It has to be in the product itself or just packaging. What if a specimen is refused? Well, we can file you're allowed to file substitute specimens. There's rules around that. For the most part, substitute specimens are accepted. But one thing to keep in mind that's unique to the pharma industry is that, say you get it approved, you get an allowance from the USPTO, and if 3 years runs by, you're still not ready. Well, you can refile a trademark application. It's not a patent application. There's no issues there. We do this for a lot of clients. We have a lot of applications that have been pending for several years because we'll get a note from them, 4 months before the 3 years is up saying we're not even close. Can you refile for us? Sure. And that kicks the process from the beginning, but also prevents interlopers from coming in and claiming that brand. So that's a process that we have built in for pharma clients. So there's ways to do this, and that's how it's done. Next slide, please. Very quickly, because it's 2024, we must touch on AI. The USPTO has issued some guidelines last week, which have been getting kind of met with some chuckles in the legal from the IP industry. Basically, it amounted to, if you use AI and work you submit to us, please review it before you submit it. Okay, that's fine. How does that work for the purposes of this discussion? Well, I added this because I was reading some material in preparation for this, and it said a lot of companies are using AI, Chat GPT and similar, using getting outputs for new names for products. So that's going to happen in the pharma industry. People say, give me some new names for brands for a cancer drug, and Chat GPT may spit out something, and that's going to happen. If that's done, I would, if you want to do that, that's great, but I'd still strongly recommend going back and following the process that David outlined earlier, because doing that is not going to pick up on, they're not going to pick up on similarities of other market brands that are out there. And it's not a substitute for doing a search and doing search things that we discussed here today. Next slide, please. Questions? Thank you.
Thank you very much. We do have a few questions. We're coming right up on the 3 o'clock hour, so I'll try to get just a couple of them in, if that's all right. So first, we have a question: at what point in the U.S. filing procedure can someone begin to file in other countries as well?
At any time. But if you file within the 6-month period, you get priority back to the U.S. filing date. But you're not barred. It's not like a patent where you're barred. A trademark can be filed anytime. But if you file within the first 6 months, you get priority back to the U.S. filing date.
Is the 2-letter difference between a potential name and a pre-existing mark an actual rule of thumb in legal examination, or is it more of a regulatory concern?
I mean, it's essentially the analysis is any letter or combination of letters or syllable, right? There's no precise indication in the case law. It's just the overall commercial impression. So, for example, a one-word mark versus a mark that maybe shares that same term but has other words in it, then that is a consideration. So, of course, the more letters are in common, the worse it is. But if there's more terms in it, then the confusion is lower. The likelihood of confusion is lower. So there's no per se number of letters, but it's just really an evaluation of the overall commercial impression. So it is not necessarily legal. It's really just an overall assessment.
Thank you. We have a question about if you have a trademark infringement case that does go to trial, how much weight does it carry if they went through the PTO clearance process and their name was unopposed? Does that matter in their eventual infringement case?
It's typically only matters for a question of monetary damages, for monetary remedies. If there's an infringement, because trademark infringement by definition is considered, it is first and foremost an offense against the public. So it's the goal of the trademark laws is to prevent the public from confusion. So if a court determines that the two names are too similar, that the public's going to be confused, the court's going to say, well, you may have had good intentions, but still we can't allow the public to be confused. So we're going to go for infringement. But if you did everything the right way, you still wound up here facing an infringement charge. We're not going to hit you with a monetary remedy or attorney's fees if you acted in good faith.
Thank you. Is it typical that a legal department at a pharmaceutical company would be both evaluating the regulatory risk and the legal risk when they're coming to a determination about a mark that they intend to use? Is that something that they typically outsource, or does it depend on the company?
I would say it mostly depends on the company, but the answer is yes. Most of that's done in-house. From my experience with clients, we'll get something by the time Rothwell Figg gets it. They've already done some pre-clearance in-house, and we'll get a list of 6 names to search and clear for them. But the process and then the FDA process is already along the way as well.
And then there's a question about if you are going through the US filing process and simultaneously filing globally, is there a risk of leaving the name more open to an attack? Is that threat neutralized once they've reached registration in one jurisdiction or another?
Well, once you've got your filing date in the US, you file within priority, that your filing date's back to the US state. I mean, there's always a risk that you could get challenged in another country. If you get challenged in Japan, that doesn't affect your rights in the US or in any of the other countries that you filed in.
Okay. Well, I think that was a great response from our audience in terms of questions. We appreciate those. And Leo and David, thank you very much for your time today. This topic is a big concern for a lot of our listeners, and we know that your expertise will be a valuable resource for them.
It was our pleasure. Thanks so much.
Our pleasure.